welcome you again to the quarterly webinar from AfroVest Trustees. Okay, so we reached out to subject matter experts, to, also contribute to this topic. And in terms of subject matter experts, reached out to Chubawale, Medidem, and Bello law practice. And representing them is Taiwo Adedoyin. Welcome, Taiwo. And of course, I have my wonderful colleagues. For those of you that have frequented our webinars, you're familiar already with the name Ebundu Atubobo, Samuel Akor, and we are going to be educating you today on, investor protection and, basically how trustee services and due diligence can save you from a lot of heart pain. So I'm going to be handing over to Taiwo right now. Taiwo, are you ready for us?
Hello, everyone. My name is Taiwo Adedoyin, Executive Associate at Chubawale, Medidem, and Bello. It's an honor to speak with you today on a subject that is vital to both investors and financial services at large. That is investor protection through trust services and legal due diligence. I'll be taking you on the legal due diligence, while my distinguished panelists will take you on the trust services with regards to investors protection. So as Nigeria deepens its investment landscape, ensuring robust legal frameworks and oversight mechanism becomes non-negotiable. Basically, legal due diligence is that silent force behind every successful investment, basically spotting landmines before they basically explode. Why legal diligence matters in investment decisions, you may ask. Legal due diligence is basically a structured process of evaluating the legal health and risks of a business before committing your capital, that is your money. And it ensures that investment decisions are informed, secured, and compliant. What are the benefits of this? It identifies hidden legal risk, such as pending litigation and tax debts. It ensures statutory regulatory compliance, that is filings to the SEC, which is Security and Exchange Commission, the Corporate Affairs Commission, CAC, the Central Bank of Nigeria, CBN, and the Federal Inland Revenue Service, the FIRS. It also classifies asset ownership, intellectual property, and contract rights. It also aligns expectations between investors and investees and provides informed valuation, that is, insights that can affect valuation and terms of investment. An example is for a tech startup boasting rapid growth can later be found to be embroiled in pending litigation, debt, or tax dispute post-investment. That is why a proper legal due diligence will flag this before you invest your money, thereby guiding your investment decision. Now we would look at the overview of capital raise transactions. A capital raise is basically the process through which a company secures funding to finance operations, expansions, or specific projects. While pitch decks and growth narratives may capture investors' interest, understanding the legal structure of the raise is very, very essential. Each form of capital raise carries distinct legal, financial, and strategic implications that affect investors' rights, obligation, and exit potential. Now, what are the common capital raise structures? We have the equity raise. The company here issues shares to investors in exchange for capital. Basically, investors then gain ownership and potentially voting rights and dividends. Here, ownership and control rights are shared. It is subject to CAC and SEC filings, may trigger dilution of existing shareholders. It requires shareholders' agreement outlining voting rights, board representation, exit mechanism, and dispute resolution. We also have the debt raise. The company here borrows capital with a promise to repay the principal plus the interest. Investors do not receive ownership here, but act as creditors. Here you have legal documentations which would include loan agreement detailing repayment terms, interest rates, covenants, and events of default. It may also require registration of charges such as the collateral. And in cases of default, legal remedies may include enforcement actions, foreclosures, or receivership. We also have hybrid and convertible instruments. Instruments such as convertible notes or safes, which is the simple agreement for future equity, are commonly used in early stage investment. These basically begin as debt for quasi-equity and convert to equity upon certain trigger events such as future funding rounds and valuations. This requires clearly defined conversion terms, including valuation caps, discount rates, and rights post-conversion. That is, rights post-conversion to equity. It also often differ ownership and governance rights until conversion. Why this matters, you may ask? Each capital restructure comes with different levels of risk, control, priority in repayment, and legal rights. For instance, equity investors here bear more risk, but may gain influence over company direction. Debt holders may have less risk, but lack upside from company growth. Convertible instruments provides basically flexibility, but carries uncertainty until conversion. Legal diligence is essential to understand these implications, very, very essential. It ensures that regulatory compliance is done and also confirms that the structure aligns with the investor's goals and risk tolerance. A due diligence tip for you here is don't just review the pitch deck. Demand access to legal documentations, ask about regulatory filings, and understand the full implications of the restructure before you commit your money, that is your capital. Now, what are the legal documents to review before you invest your money? Before committing capital, investors must conduct a meticulous legal review of all core documentations governing ownership, rights, control, and risk. These documents not only define the legal relationship between investors and the company, but also serves as a foundation for future enforcement, protection, and exit. The key documents that must be reviewed as part of legal due diligence are: one, you have the shareholders agreement. This is a very important agreement that outlines the rights and obligations of shareholders. It defines voting rights, decision-making thresholds, transfer restriction, tag along rights, and dispute resolution mechanisms. Dispute resolution mechanism in the sense that in the agreement, you may have that in the event of dispute, you might go for mediation or arbitration before litigation. It also governs the exit options, such as buybacks, IPO triggers, or M&A participation. Shareholders agreements are very essential for aligning interest and managing future conflicts. Another agreement to look into is also the subscription agreement. This details basically the terms under which investors subscribe to or purchase shares in the company. It includes investment amount, valuation, share class, that is the type of shares, payment terms, and representations and warranties made by the company. It often contains indemnity clauses and closing conditions that protect the investors. Also, you need to look at the corporate governance framework. This basically describes the internal management structure of the company, It includes details of the board composition, voting procedures, committees, and compliance with regulatory and fiduciary duties. A clear governance framework is vital to ensuring transparency, accountability, and also oversight. What are the red flags here that you should look out for? Absence of a comprehensive shareholders agreement or governance framework is a serious red flag, especially in startups or family-owned businesses. This basically increases the risks of governance deadlock, unauthorized share transfer, and legal disputes. A tip for you here, a due diligence tip for you is that you should always request the full suite of legal documents early in the investment process. Involve legal counsel. Very, very important. Involve a legal counsel. Most people run away from legal counsel, but at the end of the day, you come back to us and it may cost more at that point. So yes, involve legal counsel to identify vague clauses, missing protections, or terms that contradict investors' expectations. Now, what are the critical legal red flags in capital raises? Investors should be very vigilant for red flags, such as unclear valuations. Basically, what do you mean by, what does valuation mean? Valuation is basically is central to any investment decision. It determines how much of the company you receive in exchange for your capital. When a company's valuation lacks transparency or credible methodology, investors face the risk of overpaying for equity or missing red flags such as hidden liabilities or inflated assumptions. Why this matters? It basically over-evaluation results in investors receiving less equity for their money, which is their capital. Speculative forecasts and unverifiable data distort financial expectations. Hidden liabilities such as pending litigation, tax defaults, or unregistered IP can artificially boost valuation and lead to losses post-investment. Lack of valuation clarity means you are basically investing without a reliable compass. What are the common valuation methods? We have the discounted cash flow. This basically projects future cash flow and discounts them to present value. This is best used for stable revenue-generating companies. We also have the comparative company analysis, which benchmarks the company's value against similar companies in the same industry and market. We also have the asset-based valuation, which is basically straightforward. It calculates the company's value based on its tangible and intangible assets, minus its liabilities. What are the due diligence checklists here? Always request and review the underlying assumptions behind financial projections. Check for inflated revenue forecast or unrealistic market share growth. Confirm actual ownership of assets listed on the balance sheet. Ask for third-party or independent valuation reports where available. Compare with industry benchmarks and historical performance. Major red flags to watch out for here is no documented valuation method provided. That is a red flag. Valuation based on speculative forecasts with no historical track record, a red flag. Absence of financial statements or unaudited accounts, major red flag. No explanation for key drivers of value, a red flag. Pushback or reluctance to disclose valuation methodology during due diligence, major red flag. What is your due diligence tip here? Evaluation without supporting financials is not a valuation. It is basically a guess. Demand transparency, validate assumptions, and consult independent experts if necessary, like your lawyer. Now we'll look at dilution risk. Dilution basically occurs when a company issues new shares thereby reducing the ownership percentage of existing shareholders. While new capital can help a company grow, failure to basically include protective provisions can lead to significant erosions of value for early investors. Why does this matter? It matters because it reduces ownership percentage. Basically, investors end up owning a smaller portion of the company. It also weakens voters' power and influence, especially critical when strategic decisions require investors' input. It diminishes shares of future profits or dividends. It impacts exit returns, and smaller equity stake leads to lower returns upon IPO, acquisition, or buybacks. An example for you is that an investor with 10% equity pre-series sees their stake drop to 6.7% after the company issues 500,000 new shares. Basically, without contractual protection, this dilution is irreversible. Another example is an investor who buys 10% of a company at 100 naira per share finds that the next funding round is priced at 50 naira per share. Without anti-dilution protections, which I'll talk about later, their shares basically would lose value and their stake is reduced. What are the mitigation measures? Like I said earlier, one of it is the anti-dilution clause or clauses. This basically adjusts the investor's equity position when shares are issued at a lower valuation than they originally paid. Here we have the full ratchet, which adjusts the original price per share to the new lower price. We have the weighted average, which adjusts based on the number of shares issued and the price. Another mitigation measure is the preemptive rights. This basically grants existing shareholders the right to participate in future funding rounds in order to maintain their ownership percentage. Another mitigation measure here is the investor consent rights. It requires investors' approval before issuing new shares, especially at below market valuations. The due diligence tip here is that you should always review shareholders' agreements and subscription agreement for the presence of enforceability of anti-dilution protections and preemptive rights. The absence is a major red flag, particularly in any early stage investments where future fundraising is likely. It is very important to note that dilution is not inherently a bad thing. It often accompanies growth. However, unchecked dilution without proper safeguards can undermine an investor's financial and strategic position. Legal due diligence must always account for the terms and triggers of dilution-related clauses before funding is committed. Now we look into the exit options and liquidity terms. A key pillar of investor protection is having a very clear, enforceable exit mechanism and liquidity terms. Without this, investors risk being locked into long, illiquid positions, especially in startups or private companies where secondary markets are limited. Why it matters, it ensures investors can cash out and realize gains. It prevents indefinite capital locking. It enhances negotiating power and confidence in high-risk investments. Common exit mechanisms here are IPO, public listing, which enables investors to sell their shares on the open market, offering high liquidity and potential upsides. Another exit mechanism here is the mergers and acquisition M&A. Basically, it's the exit via trade sale to a larger company. This is common among startup ecosystems. We also have redemption rights and put options. Redemption rights requires the company to repurchase shares after a defined period. Put option investors here have the right to sell shares back at a predetermined price of formula. These are vital in cases where the IPO or M&A may not materialize. We also have the tag-along rights, which allows majority investors to sell their shares alongside majority shareholders during a sale, ensuring proportional exit. Drag along, as the name implies, enables majority shareholders to compel minority shareholders to sell, ensuring the deal is complete. Exit mechanisms, typically 5 to 7 years. Investors here should look for contractual provisions that define a timeline or expected exit for liquidity events. Liquidity terms. Beyond exit strategies, liquidity terms in investment agreement define how and when investors can access their capital. The key liquidity terms or clauses to review are your lockup periods. These are restrictions on selling shares for a set period after an IPO. We have the liquidation preference, basically ensures investors get paid first or more in the event of company liquidation. Redemption clauses, legal rights to demand, which are legal rights to demand the buyback of shares after a certain time. Predefined exit triggers, basically specific events that activate an exit or liquidity rights. Red flags to watch out for here is basically no exit mechanism defined in the term sheet or shareholders agreement. That is a red flag. Absence of redemption rights or exit timeline, especially in long-term illiquid investment, a red flag. Vague or discretionary language around liquidity triggers, a red flag. No protection against founder and company or company delay tactics, that is also a red flag. Now, it is important to always scrutinize shareholders and subscription agreements for exit paths, liquidity clauses, and enforcement timelines. Lack of these terms is a serious investor risk. Now we'll look at the regulatory non-compliance. Regulatory compliance is a non-negotiable pillar of any sound investment. Failure to comply with statutory obligations such as filing, licensing, and tax requirements can expose both the company and its investors to significant legal and financial reputational risk. Regulatory compliance refers basically to adherence to applicable laws, regulations enforced by agencies such as the Corporate Affairs Commission, CAC, the Federal Inland Revenue Service, FIRS, Securities and Exchange Commission, SEC, Central Bank of Nigeria, CBN, National Pension Commission, and so on. What investors' due diligence should confirm? Proper incorporation. This is up-to-date CAC filings, e.g. annual returns, share allotment, directorship changes. 2, valid tax compliance, that is tax identification number, tax clearance certificates from FIRS, LIRS, or other state revenue service, as the case may be. Industry-specific licenses such as CBN licenses for financial institutions, SEC registration for investment businesses, other sector-specific approvals or permits. Due diligence should also confirm employee welfare compliance, that is pension scheme registration and remittances, contribution to the National Housing Fund. Due diligence should also confirm no regulatory sanctions, that is, you review company history for fines, enforcement actions, or license suspension. Now, what are the consequences of non-compliance? Regulatory sanctions or business shutdown. Operating without proper licensing or failing to file statutory documents can result in forced closures or penalties. You have also legal liabilities for investors, particularly for investors with board seats or oversight roles. Regulatory breaches may result in personal exposure. Another consequence is also the inability to enforce investment contracts. Investment in unregistered or non-compliant companies may be deemed legally unenforceable. Now, this is very important because when doing your due diligence, you have to confirm that the company is actually registered. Because if post-investment, you find out that the company is not a registered entity, enforcement is basically going to be very tricky. Enforcement options, that is. Now, you also have reputational damage. Investors associated with companies facing public regulatory issues may suffer brand or credibility loss. You also have loss of funds. Now, a perfect example of lack of due diligence here is the recent news about CBEX, where a lot of people invested in it and lost their funds. I believe a proper due diligence would have exposed a lot of shortcomings and would have prevented people from losing their money. Also, in extreme cases, investors' capital may be irrevocable if regulatory interventions invalidate company operations. What is the due diligence tip for you here? Always request and review official regulatory documents and certifications. If a company is unable or unwilling to provide evidence of compliance, it is a major red flag, no matter how promising the opportunity may appear. So to conclude, in a world of investment, legal due diligence is basically your seatbelt. Exit options are your emergency brakes, and trustees are your airbags. By reviewing key documents, protecting against dilution, insisting on realistic valuations, and demanding transparency, investors secure both capital and confidence. Thank you for your attention. I would hand over to my fellow panelist, Ebunonua, who would continue with the trust services.
Thank you very much for that introduction, Taiwo. You did a good job in, basically laying down the foundation for people to look out when basically they are trying to, invest or get involved in capital market transactions. I will be taking us basically through the role of trustees as safeguards in terms of investor interest when we are talking about, investing in these sorts of transactions. So most of us know, have an idea of what a trustee is. A trustee is basically an independent neutral party that, is responsible for protecting investors' interest in this particular case. Right. And in terms of investment structures, there are particular roles and duties that a trustee is deemed to seem to have. So what are some of these duties that a trustee should do when we're talking about these investment structures? A trustee has a duty of loyalty, being that a trustee is seen to be independent, is seen to be a neutral third party. The trustee still has to act solely in the investor's interest, and this is because the investors, you might have 500 investors and they may not all be able to present or be able to be guided in terms of their rights. But if you have a trustee, the trustee can be able to look out for the investors and ensure that the promoters or the capital raisers act in accordance to the metrics of the transaction. So here the trustee ensures that the investors' rights are protected. It avoids any conflict of interest or any favoritism towards any third party. Also, the trustees, hold a duty of care because the trustees must diligently ensure that the promoters or whoever, are looking to issue that capital market raise or the debt issuance or the note issuance, whatever situation it may be, have, the legal capacity to do that, right? So the trustees must diligently oversee the trust, assess the risk, and ensure that, compliance is being met in such transaction. We also have the duty of prudence, because also, the trustee has that duty to manage the trust asset, to make sure that, yes, in as much as they are, holding this trust asset for the sake of the investors, and they are standing in the gap for the sake of the investors, they need to make sure that, yes, the trust assets are being managed appropriately. And obviously, to grow the assets, they can be avenues where such assets are invested, right? So it's the duty of the trustees to, act in prudence in relation to these matters. Also, there's that duty of accountability. The trustees must be transparent, and they must maintain, accurate records, provide regular reports and updates to the investors. So be it a 5-year bond term, or a 5 or a 6-year term, depending on whatever tenor of that particular transaction, the trustee must ensure that during the lifetime of that transaction, there's transparency, there records that are accurate, and obviously reports that are regularly provided to the investors to even give them an insight as to how the funds are doing or performing. Right. So in the context of these sort of transactions, what then are the role of the trustees? What do we see the roles of the trustees to be in the context of these transactions? For the debt capital markets, for example, where you have, a lender coming to the market, a borrower comes to the market and saying, okay, you know what, they want to, issue a debt note, and then, there has to be a security in place, so that in case the borrower is not able to, meet up with the terms of the repayment, something can be held on to by the investors. The role of the trustee here is to hold the security and enforce the bond terms, so that if there is any issue, or if there is any breach in the fulfillment of the obligations by such borrowers, the trustees can be able to, protect the investors' interest. In collective investment schemes, trustees have the duty and the role to basically, have an oversight function and protect retail investors, because in collective investment schemes, you can have about 1,000 to 2,000 investors in that program, and it will be quite tardy, or it will be quite, rowdy if you have each investor trying to lay a claim to their rights. But if you have a trustee in this circumstance, you are very certain that, the trustee will be able to, look after the investors by providing, an oversight function, and by also protecting their interest. In the aspect of real estate investment trusts, what the trustees do here is they basically hold the title also, and they manage the investors' interest. In terms of project and infrastructure finance, the trustees ensure that, there is a easy control of disbursement, there is an easy control of the way the revenue flows, and the revenue is being, reinvented into the transaction. So the trustees sees through these processes and ensures that, these processes are being handled well. In terms of escrow arrangement, where you have a borrower and a lender, and they need somebody to basically hold the security for the lifetime of the transaction, you have the trustee present to hold these funds or documents pending when, the terms of that transaction have been realized. So the role of the trustee and the duties cannot be oversized when we are talking about, capital market transactions, or basically investment, because you need a trustee to protect your interest. You need a trustee to be able to stand in place for you, to ensure that, if there are any issues that may arise as a result of a breach of default by the borrower, the trustee can be able to, stand in your place and ensure that, you get justice, basically. So what's exactly are the key investor protections that are being offered by trustees in these instances, right? Transparency and accountability. Trustees offer transparency and accountability to these sort of transactions because they are regularly reporting on performance of the transactions, right? The trustee is not just on the transaction to just protect the investors' interest. They also, do some administrative work by providing regular reporting on the performance of the transactions, by disclosing, material events, should in case there is an event where the company is looking at, liquidation or dissolvency. The trustee can be able to look at all of these things and disclose to the investors that this is what is happening, right? There is also the monitoring of, compliance. The trustees ensures that every single thing that has been done, even down to how the funds are invested, are being compliant, right? The trustee also has the duty to be transparent and accountable in terms of giving early warning on risks that may be attributed to that investment or that particular transaction. The trustees also play a very particular important role in protecting investors' interests through enforcement and remediation. And this is because if the trustee does not have the power to be able to enforce the right to recover investors' funds through the security, then it means that basically the trustee in this case is a toothless bulldog. So what then happens is that the trustee should have the authority and has the authority to act on behalf of the investor should there be any default or breaches, and also initiate legal actions or appoint receivers should there be a case whereby the borrower is incapacitated to be able to deliver its objectives. And also investor representation is also the duty of the trustees to represent the interest of the investors, act as a unified voice for the investors, because like I said, you have so many transactions, or some transactions where there are over 500 to 1,000 investors. Do you then have each investor try to lay a claim? That may be sort of too rowdy. And then when you have the trustee that can serve as that single body representing the voice of every single person, that is much more tidy, and that is much more efficient, especially in syndicated transactions where you have multiple lenders to that transaction. So what is the value of independent legal advice? My learned colleague Taiwo has earlier told us why it's very important for us to have certain things in place when considering investing in a particular transaction, or when even trying to go into the market. So it is very paramount to understand that independent legal advice is indispensable, and it is not optional. It is very crucial. This is because it ensures that all parties, investors, trustees, and promoters understand their rights and obligations. So if you have a transaction where somebody is looking to go into the market and there is no independent legal advisor to advise the parties on the transaction, and then the person eventually goes to the market, you can be sure that there may be some issues that may arise, because there's been the absence of a legal mind to the transaction that has been able to come into the place and say, oh, this is the way the transaction should be structured, this is how the transaction should go, and these are the things that should govern this transaction. So as simple as a single poorly worded clause can lead to significant losses for investors. It can lead to lengthy litigation, or bring a myriad of issues. But if you have an independent, well-experienced legal advisor on the transaction that is able to advise all parties, you can be sure that to a very large extent you'll be able to mitigate all of these problems, or avoid all of these issues. And that's why when you have these legal advisors also on the transaction, they're able to make situations for breach remedies. They're able to mitigate against unaddressed risks and what have you. So what are the value of independent legal advisors to the trustees and also to the investors? To the trustees, it enables them to understand the scope of authority and discretion. So it's the value of a legal advisor on the transaction can be able to tell the extent of authority or discretion that the trustee should have to a transaction. And while for investors, it enables them to understand the legal structure of the investment, and enables them to say, okay, you know what, this investment is running for a tenure of 5 years at a yield rate of 20%, discounted rate of 18%. The legal advisor helps the parties to understand these structures. Also for the trustees, independent legal advice is very important because it enables them to know when to act unilateral or to seek investors' instructions, while for the investors, it helps them to identify, conflict of interest, risks, or unusual terms. Also, independent legal advice is amazing because for the trustees, it helps them to establish liability shields in case, you know, they acted in good faith and whatever happened was beyond, you know, the natural foreseeable circumstances. Whilst for investors, you know, legal advice, obviously, it enables them to be sure that yes, there is an accessibility of arbitration or jurisdiction clauses. Whilst for trustees also, having an independent legal advisor on your transaction basically, you know, helps you to navigate complex or cross-border distressed investments. While for investors, you know, it can also just, you know, help you to understand and to confirm that the commercial terms match the legal documentation. So in as much as each party has its own duty, its own usefulness, and its own importance in terms of the capital market transaction, it is very, very important that we do not overlook the effect and the usefulness of having an independent legal advisor for our transactions. Look, be it you as an investor, or be it you as a promoter, right? So how do you basically align legal structures with investment strategy? Because, you know, it's very important that you have a strong legal structure, and this is because a strong legal structure enables you to outline all the possibilities and all the situations that may arise in that transaction, right? So it is very important that you do not have a legal structure that is basically templated. Some companies are notorious for basically templating, you know, a transaction document to fit future transactions, and this is wrong because each transaction is sui generis. Each transaction has its own, you know, effect, has its own beauty about it. So you must be sure that whatever documentation you are preparing at that time is able to cover for that particular transaction in its effect, and it's not just, you know, a generally worded clause. Because if that happens, what that means is that if there is a situation that arises that is peculiar to that transaction, and that situation has not been covered for in that documentation, this has already caused for the possibilities of a litigation or for investors' funds to be eroded or what have you. So it's very important that, you know, the transaction documents are well, you know, drafted by the legal advisor, and the trustees also play a proactive role in ensuring that, you know, the clauses in this document are enforceable, and, you know, the investors at any point in time have access to their funds should there be a breach. So what exactly are the importance of, you know, the legal structures with investment strategies? Reviewing and negotiating trust deeds. In terms of the trustees and the lawyers, is very important because, you know, when you are reviewing and negotiating these trust deeds, the legal structure is very important. The security documentation, the review of it, the intercreditor agreement, trying to ensure that, you know, everything is in place. Legal structure is very, very important for it. Also, being able to highlight legal and operational risks, especially situations where, you know, high tax, you know, charges may be affected, or there are regulatory or insolvency implications. It is very, very important that, you know, there is a legal structure that aligns with your investment strategy. It's very important that there is a strong legal structure that, you know, backs up all of this. Also, in terms of recommending enhancements, such as escrow arrangement, waterfall payment structures, or collateral packages, you know, having a trustee and also a very, you know, independent legal advisor on the transaction, it is very important. It is so much important. So ladies and gentlemen, you know, I cannot overemphasize the importance for us to, you know, sit back and not rush into certain transactions. Always be sure that you've dotted your I's and you've crossed your T's before you look into entering a transaction. And like my colleague Taiwo earlier said, the CBEX, you know, is an unfortunate event which happens to be, you know, a very good point for people to understand the need to be very careful before you decide to, you know, proceed to either investing or proceeding to put your monies in any investment bucket. And on this note, I'll be handing over to my esteemed colleague, Damilare Adeogun, who will be taking us through real-world scenarios and lesson learned when it comes to having a proper structure for your investments. Thank you.
There is an instance of a real estate project where where Nigerians in diaspora wanted to invest in the project, and, you know, they had promised 25% of the project to they had promised 25% of their project to these investors, and because there was no trustee involved, some things actually went bad. The promoter did not hold and put bad title. The land was under government acquisition, so it means that all the investors that put the fund into that project, had to lose their investment, right? The returns projected was unrealistic. When someone always explains to me that Excel, what you put on Excel is always, not even might, is always going to be different from what happens in reality. So don't just be, fooled by the presentation they give you in the Excel document or in their pitch document. Always do your due diligence and ensure that, they meet up to, they account for everything possible, from inflation to, even case scenarios. So you have best case scenario, worst case scenario, and, like a base case scenario. Then in another instance, right, this is actually a practical example. There was this real estate, land banking. They wanted land banking arrangement, and then they wanted people to invest into this land banking in exchange for a digital version of that land, right? And it was in the course of due diligence that the trustees were doing due diligence that we found out that the land that they were putting up for land banking wasn't even theirs, right? Of course, they had some back-end understanding with the landowner, but the transition has not fully occurred. So if investors have dropped money as at that period, right? And I mean, it so happened that the landowner went back and forth and said, okay, this is not what I agreed, this is what we agreed. And, basically those that had invested did not really have anything to hold on to, because on the back end, the paperwork wasn't finalized. And, in this world, in this day and age where you can even clone documents, we have seen people where they clone, they forge title documents, so you seem it to look like it's real. If you don't do adequate due diligence, you'll be surprised what you find out. So always have a trustee on ground, always have a trustee play an important role in your due diligence. And of course, like my solicitor said, always have a solicitor to play an important role in your due diligence. So look out for CAMA 2020 and SPVs. Those are ways in which the trustees can protect you. Another way we do that is holding the title in trust. We can put share charge on the shares of the company, be it a startup, be it such that if anything happens, you own shares on the startup, and then we can move on those shares to take over control of the asset. You can have equitable liens and like charges, put funds in escrow and discharge it at milestones, right? If you can outsource KYC and due diligence, please do, right? And let me just make a clause that you even doing all this due diligence does not guarantee that the intention of the person is pure, right? So they might have all the due diligence might check, but sometimes the character of the person might be the one that flaws the transaction, right? Maybe they are negligent with funds, or they're not prudent with funds, and sometimes you have to do due diligence into the lifestyle of the person. I heard of situations where foreign investors put funds into Nigerian startups, and the next week, Nigeria found that they drive Benz. Do you understand? So you have to do diligence into the lifestyle of those people you're investing into. So I don't know if there are questions and answers that people have. We're going through the chat sections now, the question and answer sections. If you have questions, please. Okay, some of them might not be able to take. Somebody is asking, carefully outline the steps of due diligence that certifications, so due diligence and what certifications to look out for. We would respond to this via email. Like I said, questions that are asked would be responded to. Some questions that are asked, if we can't take everything right now, we responded to via when we send out the webinar slides and the webinar. Please, can anyone see questions? Like for some reason, I'm not able to. Can we get the recording too? Yes, you will get the recording, you get the slides, and you get responses to question and answers. If so far we're only getting. Can someone please help me check the chat session to be sure that I'm not missing out questions? Okay, someone is asking, who is allowed by law to provide escrow services? So trustees provide escrow services. Some banks, not some banks. Banks usually have an escrow service, what's it called? Let's say department. But one good thing about the trustee, having an escrow service from the perspective of the trustees is that you have some level of flexibility, right? We can, as a bank, they just, okay, put the money in the account, and then when the terms are finalized, we can, release. But as trustees, we go in depth into the transaction. I give you an example. There was a land acquisition where they didn't trust the buyer didn't trust, the seller didn't trust the buyer didn't trust the seller. They put funds in the trustee's possession, right? And then they were like, we want to cite the document. So the seller brought documents to the trustee, right? The buyer came to the trustee's office, cited the documents, made photocopies, went to the land registry to do all that. But the truth is, some of them might not be willing to release these documents to the buyer if they don't trust that they are ready to sell. In fact, depositing funds in the escrow is proof that you are a willing and able buyer, and it changes the direction of the conversation. It means, they take it more seriously and all that. What's the minimum requirement if one needs an independent legal advice, otherwise called trustee, called trustee like Afro Invest? Well, we can take this conversation behind the camera. Okay, we can take this conversation behind the camera. Any other questions? Let me check the chat section to be sure I'm not. So bonds and shares, which one is advisable? So in the webinar, we explained that there are fixed income securities, there are equity-based investments. Equity-based investments are volatile, right? The higher the risk, the higher the return. Do you understand? They are volatile. It means if anything, for example, if Nigerian currency coughs, it can affect that. If a Nigerian production coughs, it can affect that. If, for example, if you're investing in a company like a Dangote or one of those publicly listed company, any scandal that happens in the organization affects the share price. So it can be 20 naira today, and a scandal comes out tomorrow and boom, it's down at 15 naira. Or they release their financials and people see how well they're performing, and the share price increases to like 25 naira. So, but bonds are conservative, fixed income. You are guaranteed. Your return is guaranteed. Okay, so we might not be able to take so much questions anymore because of the time. But like I said, we promise to respond to your questions via email and share with everyone that is present on the webinar. Emphasis on everyone that is present on the webinar, that's registered for the webinar, basically. I want to say a big thank you to all of you who have joined. Thank you so much to our panelists, Taiwo, Ebun. Thank you so much for sharing from your insights, from your experiences, and giving this for free to our audience. We remain available to take your questions. We remain available to serve you in any capacity under trust that you may require. And of course, SMB will be available for any legal, let's say, questions that you have. In our email, we'll put out contact details of both SMB and Afro Invest trustees so that you can reach out to us for any inquiries you might have. Thank you so much, everyone, again. I wish you a very productive day ahead. God bless you.